Very good afternoon, second time, because I was there in the earlier session as well as started the session. In this session, we are talking about decolonization, indigenization of legal education, such things. I shall be operating on a very narrow band of ideas and shall be concentrating only on what do we understand by colonization, decolonization, and how we intend to come out of it. So the strategies for decolonization. So these are the small things that I shall be talking about. This is something part of our general knowledge that for a very long time it's talk of the town, and a couple of Supreme Court judges, including some of the chief justices of Supreme Court, they have been talking about Indianization of legal education. National Education Policy 2020 also talks about as to how do we try to, it talks about the objectives of legal education basically. And one of the speakers in an earlier session was talking about those objectives. I just pick up 3 objectives for the purpose of brevity. Talks about that the legal education has to be globally competitive, talks about must be reflective of constitutional values like justice, social, economic, political, and then legal curricula must reflect socio-cultural context. So my attempt here is just to understand the colonization, decolonization, and the way we go about it. In the broadest sense, the idea of colonization or decolonization, whatever, you see, it talks about those independence struggles that the colonized societies had against the colonial orders, which was obviously for the purpose of political independence, economic sovereignty, and freedom of the subject population from the project of cultural imperialism. This is something which I would like you to take note of, that the idea of colonization is basically a kind of an inception that was played upon the minds of the colonized population, whereby the kind of a culture that they wanted to propound was no more external to them, rather it becomes part of their consciousness, which was played upon over and over again, leading to creation of a sense of inferiority, sense of, what should I say? These were some of the, issues that it actually erased cultural memories, infuses the mindset of sense of inferiority, introduced a conceptual vocabulary, and instituted hegemonic perspectives. Something we need to understand and appreciate it. Some of the colleagues were talking about those problems that an educationist in a law school system is subjected to, the kind of a predicament that we face, where students find it very difficult to really master the language and move on. What basically is a kind of linguistic hegemony, if I put it that way. Friends, this colonization basically is a subject which is associated with some kind of power asymmetries between colonized and the colonizer, whereby the dignity and the honor of the colonized people is lowered or is compromised. When we talk about legal education, and what do we mean by decolonization of legal education, it refers to or reflects incompleteness of the decolonization project. So we have decolonized in terms of our political sovereignty, in terms of our economic sovereignty, but this area remains colonized. That is the kind of idea that decolonization of legal education actually reflects. Fortunately or unfortunately, whatever you call it, for me it is unfortunate that the kind of patterns of legal education and pedagogies that we practice, it still respects the colonial order. In fact, there is always an assumption that the legal theories that we teach, they apply to all kinds of social situations, irrespective of social and cultural settings. We need to be appreciative and understand this idea. This actually disseminates a colonial mindset and a conviction that West is wiser and has all kinds of panacea for the ills that we face in this social setting. In fact, we would call it Anglo-centric, but more appropriately it would be called Anglo-American setting, or Anglo-American centric in every dimension. You may call it cultural ethos, curriculum formation, teaching pedagogies. Everywhere you find this Anglo-American centrism in legal education as the presiding idea. In fact, that way, Indian legal education is Indian only in its location. For all practical purposes, you talk about anything, teaching pedagogies or funding of education or FDPs that you run every single day, they all, smack of that, Anglo-American centricism, so to say, and it is only Indian in terms of its location, because we are teaching in India, so it is Indian. That is the only point I am trying to make. Educational patterns creates mindset with a hallmark of imitation and mimicry. In fact, just a few more points that I intend to quickly cover. It converts law students into expressions of technique, basically, causing their human side to atrophy. So very few students would think in terms of, as one of our colleagues in a former session was, in an earlier session was talking about, that the, students will have to be prepared for, fighting this soldiers of, rule of law and all that. We really don't realize that students are being prepared for something different. But here students are rarely aware that they need to really confront all these situations. So this colonization project actually leads to subjugation of indigenous societies, cultures and traditions, and as I've been talking about the same points, and I talked about linguistic hegemonies that system perpetuates. As I said, that this Indian legal system is legal only in its location. Please, next slide, quickly. I want to finish it off quickly. Now, this is the point that I intend to make, that if colonization led to, and there is no two ways to interpret it in any other way, if colonization led to subjugation of indigenous societies, cultures and linguistic traditions, decolonization would mean just its opposite. Which means that this incomplete project of decolonization has to be complete. So this would mean freeing the mindsets from the hegemonic legal traditions, vernacularization of linguistic traditions. So predicament Manavendra was talking about, we face, but these predicaments will be faced in the days to come. These vernacular hegemonies have got to be confronted head on. Legal curricula and pedagogies, they have to reflect local traditions. In fact, even National Education Policy talks about it. Legal theories need to reflect socio-cultural context and of local communities. And there has to be some attempt at reviving indigenous knowledge traditions. Quickly, next. So these are some of the strategies that I quickly talk about in a couple of minutes. One thing that we need to understand is that there's no single strategy. This is important that we need to, there is nothing shortcut whereby we can say that this project of indigenization or decolonization would be complete. Some kind of gatekeeping of knowledge through an ongoing reflective process by the entire legal fraternity has to be done, a process that encourages situational awareness. Building of source materials, mind it, the libraries that we have. If you intend to teach something Indian in a classroom situation, the student doesn't find a source material in the library. These libraries have been built upon over hundreds of years. So you need to develop source material for framing a decolonized post-colonial knowledge frame. recognition and validation of local knowledge. I remember, and this is not first time or only once, like you start speaking about that in our tradition there used to be yatra naristu pujante ramante tartadevata, etc., etc. And somebody stands up. This is something we have been hearing for hundreds of years. You tell us, how do you confront it? The point I'm trying to make is there are still people, and we were talking about it yesterday, who would write in defense of Macaulay. We need to understand and appreciate it, that recognition and validation of local knowledge traditions has to happen. There has to be integration of critical and indigenous legal theories into our curricula. And there has to be ideation of universally acceptable indigenous traditions. This is one of the strategies that I'm talking about. Say, for example, what I'm talking about in terms of, earlier slide please, the last point I wanted to make, ideation of universally accepted principles. Say, for example, I keep on giving that example all the time. Supreme Court talks about, while it decides a case on environmental law, talks about Indian traditions in environmentalism. Now, there are a lot of such traditions in Indian knowledge system where we can really involve in our, in our curriculum formation, and judiciary can later be, in a way persuaded to include these things. Some of the things that I am talking about, next slide please, quickly. Local interpretive traditions like Mimamsa. So we came across a session in which some of the judgments were decided by Allahabad High Court and even Supreme Court with reference to Mimamsa principles. It's not very difficult because these are very simple rules, but these things are not part of our knowledge, the source material that we have with us. So that is something, a challenge that we face. Developing projects and activities, just a few more points, and activities that are concerns of the community. Our concerns are always like when I develop a project in law, then I always look back, in those West law materials and, what is that? Several, 6,000, 7,000 journals, stock of knowledge, and Harvard Law Review and all those things we download, and then, so, I mean, we keep on reiterating those things that have nothing to do with our traditions. Inclusion of indigenous perspectives and resources could be pursued through clinical and experiential learning methodologies as well. Clinical legal education, where it has reached. Is it that after 30, 40 years of clinical legal education attempts that we have been making in law schools, we have been able to incorporate them into some kind of local concerns? No, not at all. So they have become very mechanical, so to say. And we keep on doing all those internships and externships, whatever you call it, without realizing what are we doing, whether it is, for the benefit of the community or not. Legal pedagogies need to be designed in view of existing requirements of the community, and then the judicial system can be persuaded to assimilate these ideas into adjudicatory processes. Just the last slide. These are some of my general observations, not concluding observations. Please note it. Path to decolonize and indigenize legal education is tough and long. Please remember this. It might take us centuries to build up. An element of patient conviction and persistence for generations would help us in moving towards goal. Rome was not built in a day, friends, but beginning has to be made somewhere. And this appears to be the time, and it appears to be a time which I believe now or never. Thank you so much.